So this is Maureen O Hara. She is a feminist activist, a lawyer and a legal academic. The focus of her activism and research is men's violence against women and girls, particularly in the sex trade, and the harms caused to women and children by gender ideology. Maureen has been involved in the rape crisis and women's refuge movements, and in a project providing exit support services to women in street prostitution. She is also a co-author of the Declaration on Women's Sex-Based Rights.
So I'm going to talk about the reasons why WDI UK is campaigning to restore safeguarding by ending sex falsification. In other words, we're going to campaign to remove all recognition of so-called gender identity or gender reassignment in law and policy. So we're campaigning for the restoration of the safeguarding of women, children, and other vulnerable groups by ending sex falsification in all its forms within the UK. And that would involve removing the concept of gender reassignment, which would involve repealing the Gender Recognition Act, and gender identity, which is recognised in fact, although not in law at the moment, through what is essentially self-ID. We want to remove it completely from all laws, so that would include not just the Gender Recognition Act, but also the Equality Act 2010 in England and Wales and Scotland. There's different legislation in Northern Ireland, but it's essentially very similar. Stopping the self-ID that's going on across the private sector and the public sector all over the country. WDI UK's advocacy is based on the Declaration on Women's Sex-Based Rights, which most of you will know, and that was published in 2019. The Declaration reaffirms that the rights of women and girls, which are set out in the UN Convention on the Elimination of All Forms of Discrimination Against Women, usually known as the CEDAW, is founded on women's experiences as a sex. So it's founded on gender, it's founded on sex, and the rights that women have are based, both the oppression that women experience and the rights that we have or the rights that we claim are based on our experiences as a sex. And the Declaration is founded on the view that replacing the category of sex with the category of gender reassignment or gender identity or whatever terminology is used in law, in policy, and in practice discriminates against women and girls by allowing men to claim to be women and girls. And I'll say a little bit more about that. The idea incorporated in the current law and in policy and practice as well, that men can become women, at least for some purposes, is a fiction which undermines the safety of women and children and also other vulnerable groups, for example, people with disabilities or with the types of illnesses, which means that they need intimate care. And we want intimate care for a woman. And now there's a debate going on about whether men who identify as women can provide that intimate care because they're supposedly women. So there are a lot of groups who are affected by the idea that men can become women, affected negatively. In the UK, that fiction is supported by the operation of the Gender Recognition Act 2004 and by the concept of gender reassignment, which is contained in equality legislation, particularly the Equality Act 2010, and also by the practice of de facto self-declaration of gender or self-ID, which is now very widespread. It's not written into the law anywhere in the UK at all, but it has been introduced, in fact, across the public sector and the private sectors without any public consultation and without any risk assessment. It was the result of lobbying, behind the scenes lobbying, essentially, that it's now become so widespread. So we're arguing that to fully restore safeguarding, we need to change law and policy in all these areas to end the fiction that people can change sex and to end that fiction completely. Yes, repealing the Gender Recognition Act would be required to do that, but that's not the only thing that will be needed. And in fact, what will be needed ultimately, and I'll say a little bit more about this later, is that the way in which human rights principles are interpreted by judges within the European Court of Human Rights and following them judges in the UK needs to be challenged. And then there needs to be a wholesale change in their conception of human rights, so that their conception of human rights genuinely focuses on the human rights of women. Because their conception of human rights in this area is, we would argue, not really about rights, it's about men's entitlement. I'm going to talk briefly about the provisions which underpin the recognition of gender in law, because not everyone listening will be familiar with them, but probably many of you will be familiar, so I apologise, but I just need to briefly talk about them for those who don't know about them. The Gender Recognition Act 2004 allows individuals who meet certain criteria to obtain a gender recognition certificate, which enables their so-called acquired gender to be recognised for most legal purposes, not for all purposes. There's some confusion about this and debate, but it doesn't, in fact, man who has GRC is not recognised as a woman in all circumstances, although he's treated as a woman in many circumstances and for legal purposes. The Equality Act 2010, which applies in England and Wales and Scotland, as I've said, protects those with certain protected characteristics. There are a number of different protected characteristics, and one of them is gender reassignment. And that's defined as applied to a person who is, quotes, proposing to undergo, is undergoing, or has undergone a process or part of a process for the purpose of reassigning the person's sex by changing physiological or other attributes of sex. They don't actually have to have changed any physiological attributes or done anything really. They simply have to, at a minimum, have in mind to plan to undergo gender reassignment. And the purpose of the legislation is to protect those people from harassment and discrimination. It is not to confer on them a different identity in terms of their sex. Gender reassignment has nothing to do with any kind of legal provision which says that a man could be a woman or vice versa. It's simply a provision that is meant to protect people from harassment or discrimination. Although there are many activists who argue otherwise. It doesn't apply in Northern Ireland, but they have the Sex Discrimination Northern Ireland Order 1976, which has essentially the same effect. The recognition of gender reassignment in law goes back a long way. It goes back to before the Gender Recognition Act. And it arises out of judges' application of sex discrimination law in relation to people who identify as transgender. That's how it first came about. There are other protected characteristics, I've said, and the Equality Act, for example, recognises sex as a protected characteristic, and that to some extent protects single-sex spaces and services, and it is possible under the Equality Act at the moment to exclude men who claim to be trans and call themselves women from single-sex spaces, including those with the GRC, if doing so fulfills a legitimate aim and does so in a proportionate way. However, the protection of single-sex provisions from males with a GRC, at least, has been called into question now by the Scottish Government, who've issued guidance saying that men who have a GRC, saying that they're women, are female for the purposes of the Equality Act. And the implication of that is that they can't be excluded from single-sex spaces or services, whatever the nature of those services. The women's rights organisation For Women Scotland have challenged the lawfulness of that guidance in the courts, and the case has gone to the Supreme Court in the case of For Women Scotland and the Scottish ministers. For Women Scotland are arguing that the definition of women under the Equality Act is based on biology and always has been. That was the intention of the drafters of the legislation that was introduced. The case was heard on the 26th and 27th of November last year, and the Supreme Court's decision is expected to be made known sometime this spring. We don't know exactly when. And they essentially will be deciding whether the definition of women in the Equality Act is based on biology or based on a legal fiction. If they decide it's the legal fiction, then spaces and services designed to be used by women only for safeguarding purposes, just refuges, Red Crisis services, and so on, will have to be open to men with a GRC, because they will be deemed to be women. And that will put women, and in some cases children, at risk. And it's agreed by all parties to the case that it will also mean that pregnant women with the GRC, i.e. women who have the GRC saying that they're male, will be denied maternity and pregnancy protections because they only apply to people who are legally female. And also, it's generally agreed that if the Supreme Court decided in favour of the Scottish Government's argument that lesbians will not be able to form associations which exclude men who have a GRC. So lesbians will not be able to freely associate, to form free associations in a public sphere. And that would obviously be discrimination against lesbians. So we don't know the outcome of that case yet. It's a very significant case. But whatever the outcome, I think we still need to campaign against the GRA and against all the other legislation that I've mentioned. Law and policy which enables men to falsify their sex is already eroding the provision of single-sex services and spaces and putting the safety, dignity and privacy of women and girls at risk. It's also endangering vulnerable adults in some of the ways that I've mentioned. Men are gaining access to provisions designated as female only, which I'm sure pretty well everyone here already knows, just domestic abuse refuges, rape crisis centres, hospital wards, prisons, public toilets and changing rooms, and male participation in female sports is putting girls and women at risk of physical harm and forcing them to change and shower in the presence of males who claim to be women in some circumstances. Also undermining fair participation in sport for women. I think most of us know all this, but when you actually look at all of it together in all of the different areas, it's the erosion of women's rights in all sorts of areas of life is really significant. We already know what most of the harms caused by sex falsification are, but there needs to be more widespread public awareness of them, and people need to be aware of how widespread sex falsification and its implications have become. Many of the harms that it causes relate to the fact that sex is the most significant factor shaping patterns of criminality. That's well established within criminology and the social sciences, although it's not often talked about, but it's well known. The overwhelming majority of those who commit criminal offences are males. 95% of the prison population in England and Wales is male. Only 5% is women. And that's particularly their overrepresentation in criminal behaviour is particularly the case in relation to sexual offences and other types of violent offences as well. So Ministry of Justice figures published in 2020 showed that 98% of those prosecuted for sexual offences in England and Wales in 2019 were male. And that figure is repeated throughout different studies and has been for many years. It's usually within 95 to 98, 99%. The 2021 crime survey for England and Wales showed that between March 2017 and March 2020, the majority of those who had experiences of rape after the age of 16 reported that the perpetrators were exclusively male. Women can be charged with rape as accessories. They can't actually be convicted of rape because rape requires the use of a penis. But they can be charged as accessories to rape. Sexual assaults against children, not including rape, but other types of assaults as well, show a similar pattern. In a 2019 study cited in the crime survey, and cited in a review of evidence by the Centre of Expertise on Child Sexual Abuse, 92% of respondents who'd been sexually abused in childhood said they'd been sexually abused exclusively by males. In some cases that was boys, and in some cases it was adult males. And crime data also shows that men who claim to be women often retain male patterns of criminality. Information about the prison population, for example, indicates that the proportion of male prisoners who claim to be women who've been convicted of sexual offences is actually higher than the proportion of convicted sex offenders in the general male population. It's significantly higher. Now, there could be a lot of reasons for that. These are a very small population looking at the prison population overall, but I think it's still a significant fact, whatever the different explanations might be. Figures for 2020 presented by the Ministry of Justice in the case of Crown on the application of FDJ in the Secretary of State, which was a case where the placement of men in women's prisons was challenged, suggested that 49.7% of trans-identifying prisoners were serving sentences for sexual offences, as compared to less than 20% of male prisoners in the general population. I'm going to talk briefly about some of the safeguarding risks caused by the recognition of gender identity in law and policy in three broad areas. They're not the only areas, but they're very significant areas. So the criminal justice system, the National Health Service, and schools. Within the criminal justice system, data recording about suspects and offenders is often now being based on gender identity rather than sex, which is skewing criminal justice data and making criminal justice data much less useful. We need to know who's committing offences and what sex they are in order to develop any policies or programmes to challenge offending. And the use of the preferred pronouns of suspects and offenders by the police, lawyers, and the courts, including judges, undermines those giving evidence about their experience of sexual and physical violence, who are disorientated and distressed when lawyers and judges refer to their male attackers as she. There was a time until it was challenged when judges were interpreting guidance in a way whereby they tried to force women giving evidence about their experiences of violence and sexual offences to use the preferred pronouns as well. The guidance has now been changed to explicitly say that they don't have to use the preferred pronouns because they may be very distressed by it. But everyone else in the courtroom is still using. Men are being placed in women's prisons, and prison searching policy requires female prison officers to intimately search men who hold a GRC because the fiction is that they're women, and so therefore it would be degrading to them to be searched by a man. Unless the men agree otherwise. They can agree to be searched by a man, but if they don't agree to be searched by a man, then female prison officers are effectively forced to search them, and that includes intimate searches, and some of those men are sex offenders and will inevitably be aroused by the searches. In September this year, British Transport Police authorised a policy which enables male officers who hold a GRC to search females detainees and to carry out intimate searches of female detainees. That would amount to inhuman and degrading treatment of female detainees, in my opinion, and I think in the opinion of many others as well. And it's been described by women's rights organisations as state-sanctioned sexual assault. In January this year, the National Police Chiefs Council withdrew similar guidance, which would have allowed any male who I'd said he identified as a woman to intimately search women, whether he had a GRC or not. They withdrew that under pressure because a lot of people complained about it and campaigned against it. But it seems that the British Transport Police have now decided that that type of policy is lawful, provided that the man has a GRC. That is being challenged in the courts by Sex Matters, a human rights organisation. In regard to the area of criminal justice as well, anyone can change their name and sex marker on documents commonly used to establish identity, such as passports and driving licences. And those documents can then be presented for the purposes of disclosure and barring service checks on past criminal offences. And the organisation Keep Prison Single Sex has pointed out in a publication about the disclosure and barring service that the checks and identity verification that the DPS carry out give enhanced privacy rights to people who claim to have a new gender identity, and that compromises identity verification and therefore creates safeguarding risks. So there may be, and it will be men in most cases, with offences for sexual, with convictions of sexual offences or for violent offences who are missed out, who aren't picked up on because they've changed their name. Within the National Health Service, where recognition of sex is crucial to many aspects of medical diagnosis and treatment, data collection is undermined by recording patients and clinicians according to their gender identity or their claimed gender identity rather than their sex. And male clinicians now are presenting as female. NHS guidance on so-called same-sex accommodation requires men who claim to be women to be placed in women's wards, and they're allowed to use women's toilets and bathing facilities. A Women's Rights Network report published in 2023 shows that these policies operate in a context of very high levels of sexual assault in hospitals. And in the same year, the British Medical Journal and The Guardian together identified 35,000 incidents of what they call sexual misconduct as well as sexual violence taking place in hospitals, ranging from derogatory remarks to rape. and they were recorded on NHS premises between 2017 and 2022. Rape, sexual assault, and touching without consent accounted for more than 1 in 5 of those cases. So it's a very high level of sexual assault that is taking place within NHS settings anyway. And on top of that, men are being allowed to identify as women within those services. NHS policies on gender put women, children, and vulnerable adults, such as those with physical disabilities, learning disabilities, and mental ill health, at risk. The physical and mental health of children and young people who are deemed to be transgender has been put at risk by the use of puberty blockers. Now, the CAS review has changed that. It is changing. And I think that there'll come a time when they stop using puberty blockers with young children entirely. But they are still allowing children to socially transition in schools. And children are still being taught that they can change their sex or gender. Within education, research by Lottie Moore, published in 2023, found that many schools are teaching children they can change sex, and they're socially transitioning children without their parents' knowledge. That may be reducing as there's been more debate about it, I'm not sure, but it's certainly happening. And children are permitted to use the toilets and of the opposite sex, and they're also permitted to go on school trips and share residential facilities with children of the opposite sex on the basis they are really the opposite sex themselves. And that puts the other children at risk. It puts their privacy and dignity at risk, as well as putting them at actual risk of potential sexual assault. The levels of sexual assault perpetrated by boys is quite high. Quite a significant amount of sexual assault is perpetrated by boys, and there's a significant amount of sexual assault taking place within schools, and that's now well established. Requiring girls to participate in the fiction that someone they know to be a boy is really a girl encourages them to suppress their natural self-protective reactions to the presence of males in what are meant to be female-only spaces. And that will have a knock-on effect and undermine their ability to protect themselves and to acknowledge reality, what they feel to be reality, in other situations as well. I'm just going to talk about what needs to be done to restore safeguarding and stop all of this. All of this has come about because of law and policy which allows sex falsification. I think the more we acknowledge that that's what it is, the better, because then it's easier to see the safeguarding implications of it. And so to fully restore safeguarding, WDI UK is calling for the following: the repeal of the Gender Recognition Act 2004. It's one of the foundations of the fiction that individuals can change their sex. It's not the only foundation. In some ways, it's not even the main foundation. The main foundation, arguably, at least in law, is judges' interpretations of human rights provisions. And it was because of their interpretation that Gender Recognition Act was first introduced. Introducing this fiction into law has brought about enormous confusion about the law's definitions of male and female, as exemplified in the 4 Women Scotland case. If the Supreme Court finds in favour of the Scottish Government in this case, there will be no situations in which the safety, privacy and dignity provided to women and girls by women-only spaces and services can be fully maintained. It will be impossible, because men with a GRC will not be able to be excluded from them. These spaces and services can be protected up to a point if the Supreme Court decides that a GRC does not make a man or woman for the purposes of the Equality Act. But while the GRA remains in place, it is impossible to fully safeguard women's safety and privacy. And an example of that is the searching policy in relation to men who hold a GRC, which I mentioned earlier, where female prison officers are required to search them, whether they want to or not. We also call for the removal of the protected characteristics of gender reassignment from the Equality Act. As I've said, that gender reassignment is not it's not the same as the provisions in the Gender Recognition Act. What it's designed to do is to protect from discrimination and harassment. And we propose that the protected characteristic of gender reassignment be removed from the legislation, and that people who claim to be transgender can be protected from harassment and discrimination in other ways. Some of them are harassed and discriminated against, and we're not arguing they shouldn't have any protections from that. What we're arguing is that they should not be protected on the basis that they are actually reassigning their gender. Legal academic Alessandra Astoriti has put forward an argument that instead of gender reassignment, they could be protected under the other protected characteristics in the Act. So they could be protected on the basis of sexual orientation if they are or are presumed to be lesbian or gay. They could be protected under the disability protected characteristic if they have a diagnosis of gender dysphoria. I mean, that's a disputed diagnosis, but I won't get into that just now. Or they could be protected on the basis of their belief system. And there are ways, I mean, gender critical people are now protected on the basis of gender critical beliefs after Mayor Forsata's case. There are many types of beliefs which are protected under the Equality Act, and someone's belief that they are a person of the other sex and that they're transitioning could be protected in the sense that they should not be harassed or discriminated against because of that belief, but protecting it as a belief does not recognise it as a reality. It's simply saying that's their subjective belief, and because of that subjective belief they shouldn't be harassed. So that would be a very different way of protecting one from harassment and discrimination, and the protection would then be based on material reality and not fiction. We also want to see an end to the de facto self-declaration of gender identity in public and private institutions and in identity documents, because that's what changing your name and the giving yourself a female name if you're a man in your identity documents is a form of self-ID, essentially. And it's not aligned with the current law. And the Westminster government have in fact said that they don't want it incorporated into law. They opposed the Scottish government when they tried to introduce self-ID. Nevertheless, it operates in practice. It's very, very widespread now, including in most public organisations, and we want to see that brought to an end. And that we also want all identity documents to accurately record the sex of the individual concerned. I mean, people can call themselves whatever name they want, provided that it actually says male or female. There isn't a name that is inherently male or female, but their sex needs to be recorded. We want to see an end to the confusion in law about the meaning of sex. And the case law, I think, shows that only Parliament can resolve this confusion ultimately. For Women Scotland is not the only case where the question of what is a woman has been brought before the courts, and the courts have had to look at the existing legislation and decide who qualifies as a woman in particular circumstances, which in itself, if you think about it, is absurd. So only Parliament can resolve that confusion, and they could restore safeguarding by doing all the things that we've suggested. As I've said, the main foundation of the recognition of gender identity in law and policy has been judges' interpretation of human rights principles. That's how the Gender Recognition Act came about. It followed on from the case of Goodwin in the UK, which is a case where a post-operative man who was called transsexual by the courts brought a claim under Article 8, the right to respect for private and family life, and Article 12, the right to marry. He couldn't marry at that time. He couldn't marry his male partner. Same-sex marriage didn't exist at that time. But also he claimed that his right to private life was being undermined by the fact that he didn't have any mechanism for changing his gender in law. And the European Court accepted his argument. Now, the European Convention on Human Rights provides very important protections for women and girls and children, in fact, anyone from abuse. For example, Article 3 prohibits inhuman and degrading treatment and torture, and it has been used to protect women in many situations in the case law in relation to rape and other types of violence. Article 8, the respect for private and family life, is also significant for women. However, judges' interpretations of Article 8 in relation to claimants who identify as transgender have, in the European context anyway, are what has led to the construction of gender identity in law largely. It's one of the most influential aspects of that. There are many factors that have influenced it. The medical profession has been huge, but the way judges have applied human rights principles has been huge as well. And when they've done that, when they've applied human rights principles to the cases of applicants who claim a transgender identity, they've entirely focused on what they see as the rights of that person and virtually ignored the rights of women, the ways in which women and other people will be affected by the recognition of gender identity in law. And they've also ignored the significance of widespread male dominance throughout society and the very high levels of violence against women and girls, and in fact boys as well, by men. That the fact that, so the context of offending by men, of sexual violence and other types of violence which men direct at women, internationally, it's well established that their rates of violence against women are extremely high. And the judges have never taken account really seriously of that context when they're deciding the implications of what it means to allow a man to say he's a woman and enter women-only spaces. They haven't really properly addressed that. So what I would like to see, and this is a very tall order, is a challenge to the whole way in which they interpret human rights, which we'll have to do anyway in order to achieve what we want to do, because the Gender Recognition Act is not going to be repealed and the other legislation is not going to be a change without that approach to human rights being challenged, I think. So I think their view of human rights is very male-centred, but it's also now very deeply embedded, and it will be an uphill struggle to challenge it, but I don't think it's completely impossible. It's going to be hard, and we may not succeed, but I think we have to try. As I said, the GRA came about because of the Goodwin case. Since Goodwin, there have been many more cases, and that have strengthened the idea that all states who are members of the European Convention on Human Rights must have a mechanism for people to change their sex markers in law. And the court now regards it as so fundamental that they say all states should do it, and there's a very narrow margin of appreciation for states, which the margin of appreciation relates to the concept that the European Court of Human Rights will allow a certain amount of leeway to individual states in regard to some areas and some rights according to their legal traditions and their cultural traditions. So for some areas, they allow a lot of leeway. Taxation law is one of them. It's massive leeway for states in how they organise their taxes. Anything that is seen as discriminatory against any particular group has little or no margin of appreciation at all. The margin of appreciation is very narrow. And the courts have said that for a state not to have any mechanism for people to change their gender in law is contrary to human rights principles, particularly Article 8. And there is no leeway for states who don't have that kind of mechanism. So basically, if the UK was to repeal the GRA and not have any mechanism, it's likely that, almost certain, that a case would be brought against the UK and the UK would be taken to the European Court of Human Rights. It's likely that whoever brought the case against the UK would win their case. The court would then tell the UK it should change its law. And if the UK refused to comply, ultimately, it will be possible for the UK to be removed as a member state. The only state who's been removed so far is the Russian Federation. They were removed because their aggression against Ukraine. It's never happened to any other state, but it is possible for it to happen. And so there is a risk if the UK were to repeal the Gender Recognition Act and remove all recognition of gender identity in law, that ultimately the UK could be removed from basically the European Court of Human Rights revisions, which would be serious, and I think it would be very detrimental to women if the UK was removed, because, as I said, there are important protections for women within the European Convention. I don't think we should underestimate the difficulties there will be in changing the law. If we came to the point where it could be changed, I think we'd only come to that point if there had been, at least amongst many people, a widespread re-examination of what human rights mean in this context. Is this a right, or is it an unjustified entitlement? And I think that more discussion needs to be had about that. What is actually a right? What should be seen as a human right? What should be seen as a male entitlement to intrude on females for only spaces, which is what essentially it is, or what it often boils down to. So I think that to get to a point where repeal would be likely, a government would only do it if they thought there was very, very widespread support for it amongst the general population, to the point where it could become an election issue. That's the only circumstance, I think, in which they would even consider it, because they know the potential implications with regard to non-compliance with the European Convention. And the UK is actually one of the member states which is usually very careful to comply with the convention. And if the court says it should change its law, it will change its law, generally speaking. They don't have to. If the court says that if there was a case and the European Court of Human Rights said the UK should change its law, that wouldn't mean that the law would change. Parliament would have to decide, and they could say no. It would be very unlikely that they would say no, unless they had a very firm foundation in regards to public opinion to do so. And if they did say no, the European Court and its mechanisms might or might not remove the UK. There'll be a lot of lobbying for them to do so, I think, because other states, and particularly the pro-trans lobby in other states, would want the UK removed if it did that. So it would be a serious situation. I think it would only happen if there was very, very, very widespread public support. That's going to be difficult to achieve, but I think we need to try to argue for it. And even if we don't achieve it, the arguments that we put and the debate that is now being had already, there are more and more people arguing for it. The debate that has been had already, and the debate that could be had if we keep campaigning and keep talking about it and keep raising the issue, may not bring about the legal changes that we want, but what I think it will do, or could do, is bring about other changes which will at least help to mitigate the harms that the recognition of gender identity in law and policy has created. And it might help to stop it getting worse. And I think it's worth doing it just for that reason. I don't think we'll succeed. I don't think it's easy. And if we just remove the GRA and don't do anything else, as Michael Foran, an academic lawyer who's an equality law expert, has said, the courts will simply make their own decisions and they will interpret human rights principles according to their view. And he has pointed out that the Gender Recognition Act actually helped to stop the courts going too far in some ways in that regard. I think he's right about that. So there would have to be not just a change in terms of repeal, there would have to be a much more widespread change of thinking in order to make the repeal of the GRA be what we would want it to be if we manage to achieve it. Thank you.